our health care costs under control, it'll be harder and harder for us to create opportunity here in this country, because the costs that are embedded in hiring a new employee under health care alone are so high that many companies simply aren't hiring. So we'd love to hear your thoughts on that, Dr. Barrasso.
Well, thank you very much. And Madam President, I just want to thank Senator Portman for the incredible job he's been doing as a champion of efforts to create more private sector jobs in this country, to make it easier and cheaper to create private sector jobs, for the private sector to create the jobs that we need. And Senator Portman has shown significant leadership in his campaign for the Senate last year in Ohio, developing the Portman Jobs Plan. And he went to factories and small businesses because he knows, all across the state of Ohio, because he knows that small businesses are the engines that drive the economy. 70% of the jobs created in this country are created by our small businesses, one at a time. And when there are government rules and regulation and red tape and increased expenses, it makes it much, much harder, because it doesn't provide the certainty that the small businesses of this country need in order to create those new jobs. They may not be willing to take the additional risk and the additional expense because of the unknown concerns. And I think that is one of the things that's highlighted in this wonderful plan that Senator Portman has put together along with the members of the Republican Party. A big part of this has to do with the rules and regulations that come out of Washington, D.C., rules and regulations that may not even be connected to laws that were passed in this body, but rules and regulations put forward by this administration, by people who have a different view of how America works. So I was encouraged over 100 days ago when the President said he had an executive order that would try to eliminate some of the red tape. Well, here we are, 100 days later, and it's just another broken promise from this administration. The red tape continues to hold American small businesses hostage. We're trying to cut through that red tape. And, you know, the American people realize it. The administration may not realize it, but the American people realize it. When the American people were questioned just this last month, were there too few regulations or too many regulations and the impact on business, a majority said there are too many regulations on our businesses. And how much money does Washington spend on regulations? Well, I'll tell you, Madam President, government spent a record of $55 billion developing and enforcing rules last year. $55 billion developing and enforcing rules last year. Now, that's just the spending of government. What is the impact on our businesses around the country? Well, for every $1 that government spends to put forth and enforce these rules, it costs businesses of this country $30. So over $1.5 trillion expended by businesses across the country, a drag on our economy, making it harder for them, not easier, but harder and more expensive for the private sector to create jobs. So $30 of business expense for every $1 spent in rules and regulations out of Washington. And, Madam President, people are worried because it's going to get worse. There are still 224 rules in the pipeline that have been labeled as economically significant. What's an economic significant rule? Well, it's a rule that has an impact on the economy of over $100 million. 224 of them coming down the line. Is it a surprise that the unemployment rate continues so high? And it's because of the rules and regulations of this administration. Now, what do the American people believe about this? Well, over 70% of the American people believe several different things about the effect of the rules, and I'll tell you what they are. This is polling just last month. They will tell you that additional environmental regulation increases the price of energy for things like gasoline and electricity. The rules coming out of Washington, 70% of Americans believe increases the cost of things like gasoline and electricity, the energy issues. How much is the pain at the pump costing the American family this year? Well, about $800 per family this year, higher gasoline rates than last year. Well, if you're a family, that has an impact on your quality of life. It has an impact if you're trying to deal with bills and kids and a mortgage. But there are a lot of regulations out there. So the American people see this. Also, over 70% of the American people know in their hearts and believe that small businesses, the job creators of this country, small businesses are impacted much more than the large businesses of the country. But it's the small businesses that we want to help. The other thing that more than 70% of the American people believe, is in a poll by the Terrence Group, if regulations make it too expensive to keep jobs in America, businesses will continue to move overseas. Businesses will continue to move overseas. There is so much uncertainty with the rules and regulations coming out of this town that it is paralyzing the rest of our country. And that's just on the rules and regulations aspect that people can see. There's so many rules and regulations that are still coming. One came out, I was at a hospital in Cody, Wyoming, talking about health care, because I've practiced medicine for 25 years, taking care of families all across the Cowboy State. Visiting at a hospital in Cody, Wyoming, and they're saying, you know, we're trying to figure out this one aspect of the health care law called accountable care organizations. It's 6 pages of the law, you know, that 2,700-page law that was crammed through in the middle of the night. Americans were saying, no, we don't want this. Well, the people that do the regulations, they took 6 pages of the law, and they came up with over 400 pages of regulations. They just came out about a month ago, and the hospital administrator said, you know, we're having to take money away from patient care, from helping with nurses and therapists, to pay for consultants to try to explain these rules and regulations to us so we can abide by them. Those are the kind of regulations and rules on steroids that I continue to hear about as I traveled in the last week or so at home, visiting with people, visiting in the communities, listening to what people have to say. And the concern and the uncertainty because of what's coming out of Washington is a drag on our economy. It is preventing us from making it easier and cheaper for the private sector to create more jobs. People all across the country are concerned, Madam President, and that's why I'm so happy to be here with Senator Portman today and his efforts, his leadership on a jobs plan that is one that focuses fundamentally on the things that will get government off the back of the American people and let the American people get back to work. And so with that, Senator Portman, I want to thank you for your leadership at a time when we see a government that is borrowing too much, spending too much, and growing bigger every day. And I'm very appreciative of your efforts to get things back into control and get the decisions making out of Washington and back to the hometowns and states across the country.
Well, thank you, Dr. Barrasso, and I really appreciate the amount of time and effort you've put into this regulatory issue, and the relief that small businesses need on the regulatory front is obvious if you're out talking to businesses, and it is directly related to jobs, because we can't get the jobs back unless we reduce the cost of doing business that comes from these regulations. Madam President, I would like to ask, if I could, how much time we have left in the colloquy.
12 minutes, 7 seconds on the Republican side.
Thank you, Madam President. As I've said, we are also joined by Senator Cornyn from Texas. I'm going to ask him in a minute to say a few words about the jobs plan, and the input that he's had into it has been terrific, because he's a guy who understands, again, the importance of small business, the importance of us creating the environment here through Washington laws and regulations that helps create jobs, that it's not Washington that's going to create the jobs, but in fact it's the private sector that's going to do it. And I would ask my colleague from Texas, who'd like to say a few words about his thoughts on the jobs plan.
Madam President, I would just say to my colleague from Ohio, what a welcome idea and refocusing of us on the #1 issue in America today, which is too many Americans out of work. And of course, you saw the growth numbers for the first quarter of this year, 1.8%, hardly vigorous enough to create the kind of economic expansion and job creation that we need. And as we're dealing with the spending issue, we got to deal with growing the economy, and that's exactly what the senator from Ohio has proposed here, is a comprehensive plan to try to figure out how to get people back to work and try to get the kind of economic growth which will help us deal with this debt crisis that we're in. But I would say the one thing I would that I've especially liked about the plan, although I like all of it, is the embracing of the notion of a balanced budget amendment to the Constitution. Senator from Ohio has had a distinguished career not only in the House but as U.S. Trade Representative and also as Director of the Office of Management and Budget. You know the budget numbers and the intricacies of that better than just about anybody here. And you know that the difficulty we've had, whether Republican administrations or Democratic administrations, of living within our means. And now that we're spending so much money that we don't have, about 40 cents on every dollar, with $14.3 trillion in debt and huge deficits, we got to figure a way out of that. And I think the best way to do that is to put this proverbial straitjacket on Congress and force us to do what every family and every business and 49 states do, either because of constitutional or statutory provisions. So I just want to say in conclusion how much I appreciate the good work he's done. He's been here, Senator Portman's been here a short time, but he's brings a lot of experience and a lot of wisdom on these issues, and particularly on getting America back to work. Thank you.
I thank my colleague from Texas, and he's absolutely right. When you look at the budget deficit and the debt and the impact it's having on our economy today, it is clear that we need constraints here. 49 states have a balanced budget requirement. When I'm back home talking to our cities and counties and their struggles with balancing their own budgets, they ask me, well, how can Washington continue to spend so much money they don't have? 40 cents of every dollar that Washington spends today is borrowed money. So clearly that restraint is needed, and it's important to get the economy back on track. Often we talk about the record budget deficit and the $14 trillion debt in terms of its impact on future generations. And as the father of three, I'm very concerned about that, as we all should be, because we're mortgaging their future, in essence. Excessive spending today that they're going to have to pay back. But it's not just about what's going to happen in the future. Our deficit and debts have gotten so big that they have an impact on today's economy. There's a study done recently by a couple of respected economists, Rogoff and Reinhardt, saying that in looking around the world, where a country's debt is up to 90% of its total economy, you have about a 1% decline in the GDP, or the growth in the economy. Well, our growth was only 1.8% last quarter. That means it should have been at least 2.8%, but for our debt and deficit, because now our gross debt is 100% of our economy. So we're over that 90% threshold, and we're impacting our economy today. Also, you think about it, with all the government borrowing out there, it's crowding out private borrowing. And so there are fewer jobs being created in America because the government is playing a bigger and bigger role, crowding out the ability for small businesses to get a loan. I also join a lot of other folks in this chamber on both sides of the aisle in my deep concern about the possibility of a debt crisis if we don't deal with these historic deficits and debts. And that could send our economy into a tailspin with sky-high interest rates, with inflation that's already rearing its ugly head again in this country. So we need to address this issue, both because it's the right thing to do, future generations, it's really a moral issue, but also because it does impact what's going on today in our economy, and our ability to get this economy back on track and create jobs is so important to American families, and, as I said earlier, so important to us dealing with the fiscal problems, because we've got to both restrain spending and grow the economy, increase economic activity, which will increase revenues. Madam Chair, I'd like to ask if you could give me a 5-minute warning when we have 5 minutes left in the colloquy today. And with that, I'd like to turn back to my colleague from Tennessee, who started us off this morning talking about the importance of this jobs plan. And, Senator, would you have some more comments on the plan and on what has been said by some of our other colleagues?
Well, thank you very much. And just to the Madam President, the 5-minute warning is for the end of 25 minutes because I intend to take 5 minutes after that.
There's 6 minutes remaining in total on the Republican side.
Then I'll take 1 minute and we'll conclude the colloquy with that. I want to thank Senator Portman, Senator Cornyn, Senator Barrasso for this. We'll be hearing often from Republicans who want to make clear what we're for as well as what we're against. And I thank the senator from Ohio for his leadership, and I wonder if in the last 30 seconds or so he wanted to reflect especially on trade and jobs, which has been his specialty.
That'd be great. Well, first of all, I thank my colleague from Tennessee for helping to promote this idea. And again, we're looking to reach out to Democrats in this chamber, in the House, working with the administration to actually get this done. We need to get the American economy back on track. And as I just heard you talk about trade, we talked about that earlier, but as was said earlier, we need to increase exports because exports equals jobs. And if you look at these 3 pending trade agreements that the administration has yet to send up to the United States Congress, and we can't move unless they do that, they would create alone between 250 and 380,000 jobs, depending on what numbers you look at. Think about that. Hundreds of thousands of jobs are ready to be created right now by knocking down barriers to our workers, our farmers, our service providers, just in these 3 instances alone. We also need to provide the President with the authority to knock down more barriers by giving him trade promotion authority. So I call on the administration today, send us those agreements, free those agreements up, allow us here in America to be able to create more jobs by expanding our exports, by leveling this playing field between these 3 countries, Panama, Korea, Colombia, and then let's get busy on having the United States even more engaged in international trade, expanding exports, and therefore creating jobs. Let me just review quickly these 7 core areas and then turn it back to my colleague from Tennessee. We do need to focus on the fiscal situation, as we've talked about, to be able to help the economy. Our tax code needs to be reformed to create economic growth. We can do that. We know that there is a way to do it without raising taxes by reforming the code and making it more pro-growth. The regulations we talked about that are stifling so many small businesses in this country. The competitive workforce, retraining is critical. We can do a much better job taking the existing federal resources and directing them toward retraining for jobs that are actually there. Expanding exports we just talked about, and of course powering America's economy by using more of our own domestic resources, renewable, but also our traditional uses of energy. And finally, getting health care costs down, as Dr. Barrasso talked about that. If we do these things, we will create more hope and opportunity at a time when it's desperately needed, and we should be able to do it because they're common sense ideas. Thank my colleague from Tennessee.
I thank the senator from Ohio. Madam President, we have a vote at noon. I know there are a number of senators who wish to speak. I'm going to take about 5 minutes. I suspect Senator Cornyn wants to speak. I know Senator Grassley wants to speak. I see Senator Reid. Mr. President, the Senate is a body of precedent. One important precedent is that never in the Senate history has a president's district court nomination reported by the Judiciary Committee been defeated because of a filibuster, that is, because of a cloture vote. Once a nominee for federal district judge has gotten to the floor, the majority of senators have made the decision in an up and down vote. Therefore, I'll vote today for cloture in order to allow an up or down vote on the President's nomination of John McConnell. Then I'll vote no on confirmation because I believe he's a flawed nominee. I know that most of my Republican colleagues are going to register their opposition to Mr. McConnell by voting to deny an up or down vote. I respect their decision. I understand how they feel. I also was outraged in 2003 when Democratic senators filibustered President Bush's circuit court nominees simply because they disagreed with their philosophies. I made my first speeches on the floor of the Senate arguing against such a change in precedent. On February 27, 2003, I said on this floor, quote, "When it comes time to vote, when we finish that whole examination, I'll vote to let the majority decide. In plain English, I will not vote to deny a Democratic president's judicial nominee just because the nominee may have views more liberal than mine. That's the way judges have always been selected. That is the way they should be selected." That's what I said in 2003. In 2005, Republicans grew so upset with the Democrats' continued filibustering of President Bush's circuit judge nominees that the Republican majority leader threatened to eliminate the right to filibuster in connection with judicial nominations. That proposal was called the nuclear option because it was said that if Republicans succeeded in abolishing the filibuster, their actions would blow the place up. I suggested in 2 Senate speeches that a small group of senators equally divided by party agree to oppose the filibustering of judges. The result of those remarks was the creation of the Gang of 14, the Gang of 14 senators who preserved the tradition of up or down votes by agreeing to use the filibuster only in extraordinary cases. I've amended my own views to describe to the Gang of 14 standard for Supreme Court and Circuit Court judges. It is true that the Gang of 14 agreement didn't explicitly distinguish between circuit and district judges, but the debate then clearly was only about Supreme Court and circuit judges. and the Senate has always thought of district judges differently. District judges are trial judges. Circuit judges also must follow precedent, but have broader discretion in interpreting and applying the law. Circuit judges' jurisdictions are broader. Their attitudes and philosophies are much more consequential in the judicial process. That's why the Senate has never allowed a federal district court nomination to fail by denying cloture. According to the Congressional Research Service, in the history of the Senate.
The senator's time has expired.
I ask for an additional minute.
Is there an objection?
Thank you.
No objection.
According to the Congressional Research Service, in the history of the Senate, only 3 cloture motions have ever been filed on district judge nominations. In each case, the nomination eventually was confirmed. I certainly wish that President Obama had nominated someone other than Mr. McConnell. During his confirmation hearings, questions arose about a possible role in stolen corporate documents and other questions. It was even said that he's the only district judge to be opposed by the U.S. Chamber of Commerce in its 99-year history. Well, the Senate has more than a 200-year history, and that history is not to use the filibuster to defeat a district judge nomination. I'm comfortable with the Gang of 14 precedent in the case of circuit judges and Supreme Court justices. I'll continue to reserve the right to vote against allowing an up or down vote in an extraordinary case. I also understand the strategy of they did it to us, so we'll do it to them. Unfortunately, that strategy, I'm afraid, will lead us to a new and bad precedent, one which will weaken the Senate as an institution and come back one day to bite those who establish it. I thank the President, and I yield the floor.
Madam President.
Madam President.
Senator from New York.
And thank you, Madam President.
Would the Senator yield for a quick question?
I would.
Madam President, I know there are a number of us who would like to speak on the upcoming cloture vote at noon on the McConnell nomination. I know Senator Grassley would, I presume Senator from New York, and also Senator from Rhode Island. I wonder if we could reach some unanimous consent agreement that would allow at least 5 minutes for each of us to speak. I would pose that as a unanimous consent request that for the senators who are currently on the floor, the 5 of us, we'd be given up to 5 minutes to speak preceding the cloture.
How much, might I ask a question of the chair? What is the status, the time status? There's 35 minutes till noon. Is that divided? Is that?
Yes. The Democrats, the time is equally divided. The Democrats control 19 minutes. The Republicans control 18.5 minutes.
Madam President, reserving the right to object, I want to remind the senators that this isn't the only debate on the floor, that we're having a cloture vote on SBIR, and we'd like some time to close that debate as well. So I'm open to work with you guys.
Madam President, reserving my right to object. I would suggest, according to the lines of the Senator from Texas, that the Senator from New York be recognized 5 minutes, the Senator from Texas be recognized 5 minutes. I be recognized 5 minutes, and I think Senator Grass be recognized 5 minutes. But the question then would be, is there sufficient time for the Senator from...
Could I ask unanimous?
And Leahy.
Okay. I don't know how to do this, but if we could maybe do 3 minutes each and just reserve at least 15 minutes for
time is being
closure.
consumed during this debate.
Madam President,
Senator from New York.
I believe that if we have 37 minutes remaining.
Correct.
Is that right? 19
Correct.
and 18? And I know Senator Leahy wants to close with 5 minutes. So what we could do equitably is 1, 2, 3, 4, 5, 6. Give each of the 6 members on the floor 5 minutes.
Yeah. I have to object to that.
Okay. Then, Madam President, I have the floor, and I ask to be recognized.
Senator from New York.
Madam President, I rise today to talk about a serious crisis in the third branch of government, and that is the rate of vacancies in the United States District Courts. There's a crisis that is unlike almost all of the other issues that we grapple with on a daily basis. It has a very simple solution. Now my colleagues and I deal with a lot of very difficult and very divisive problems every day. Not many of them lend themselves to solutions that are both politically and economically costless. But this one's easy. Confirm these judges. Take the district court nominees who have passed out of committee with bipartisan support, schedule votes on the floor, and confirm them. It sounds easy. Apparently, it's not. It is not easy because my colleagues on the other side of the aisle have slowed the confirmation of district court judges to a trickle. Even those nominees who have passed out of the Judiciary Committee with no objection from Republicans. This Congress, I'm grateful for the hard work of Chairman Leahy, Ranking Member Grassley, Majority Leader Reid, Minority Leader McConnell in beginning to unclog the pipeline. But we still have a long way to go. And to go the rest of the distance to restore the pace of judicial confirmations before the federal judiciary faces the worst vacancy crisis in history, we need the consent of our Republican colleagues. And here are the facts. The targeting of district court nominees is unprecedented. 5 of the 19 district court nominees who have received split votes in the last 65 years have been President Obama's nominees. We've only confirmed 61 of his district court nominees. By this time in their presidencies, we had confirmed 98 of President Bush's and 114 of President Clinton's. Judicial vacancies affect nearly 100 federal courtrooms across the nation. 1 in 9 seats on the federal bench are vacant. So we should approve these nominees. Now, as for the current nominee pending on the floor, he is somebody who deserves nomination. When we ask about nominees, we are concerned that the standard used by my colleagues is, would I have nominated this person, rather than, is this person whom I might not have nominated in the mainstream. Jack McConnell is clearly in the mainstream. He has more than 25 years' experience as a lawyer in private practice. Leading Republican figures in Rhode Island have endorsed him, but he's garnered opposition not because of his qualifications, but because of his clients. That is not fair, that is not right, and that is not how we do judicial nominees. He's chosen his work as a private lawyer, and that has no bearing on his judicial temperament, his interpretive philosophy, or legal acumen. In the interests of my colleagues who require more time, I would urge at the very least that people take the senator from Tennessee's standard. Don't block cloture on this nominee, and if you think he's not qualified, vote against him. But Jack McConnell deserves to be on the bench. I'm glad that Leader Reid has called him, and Senator Reid and White House have taken the lead, and I urge, at least on cloture, my colleagues to let this nominee be voted upon. I yield the balance of my time that I've been allotted so that others of my colleagues might speak.
Madam President.
Senator from Texas.
Thank you, Madam President. I've been conferring with the senator from Rhode Island and other senators who want to speak, and maybe if we could try another attempt at a unanimous consent request that would allow all of us a chance to speak. So I would since I have the floor, and I assume I could speak for up to 10 minutes under the standing order, but I'm willing to yield some of that time so everybody can have
Madam President, I object to any unanimous
Madam President,
consent.
I have the floor. The senator's out of order, Madam President. I have the floor. I would ask at this time a unanimous consent request that the senator from Rhode Island, the senator from
Is there an objection?
I object.
Madam President, I will proceed then under the standing order, which gives me up to 10 minutes, as I understand.
Senator's correct.
I regret the senator from Louisiana is unwilling to cooperate and provide everybody a chance to be heard. But I will proceed. I want to speak to the nomination of Jack McConnell to the federal district bench. I spoke on this nomination yesterday. I've authored a op-ed piece in the Washington Times expressing my concern, and I want to just summarize for my colleagues' benefit and their consideration my concerns. I serve as a member of the Judiciary Committee, as does the senator from Iowa, Senator Grassley, and before the Senate Judiciary Committee, this nominee was asked about allegations of theft of corporate documents arising out of some lead paint litigation that his law firm was pursuing in the state of Rhode Island, and that's been the subject of some discussion. I would like to ask unanimous consent to offer several documents at this time. First of all, Madam President, I would like to ask unanimous consent after my comments that the complaint of the Sherwin-Williams Company versus Motley Rice and others be made part of the record.
Without objection.
And, Madam President, I would ask one further unanimous consent request, and that would be that an article from Legal Newsline about a discovery dispute still delaying the resolution of the theft case against Motley Rice, that be made part of the record.
Without objection.
Madam President, what I think these documents demonstrate is that not only did Mr. McConnell intentionally mislead the Senate Judiciary Committee with regard to his possession of these stolen documents, but that now there has been for some years, even after the lead paint cases have been essentially dismissed by the Rhode Island Supreme Court, with the state and Mr. McConnell and his law firm having lost, that there is an ongoing litigation by one of the defendants in that case suing for tortious interference with their property, also conversion, in other words, theft, as Madam President knows, of their private proprietary documents, including their litigation strategy, including their trade secrets and the like. What the article that I've made part of the record shows, it's dated April the 21st, 2011, is that dispute over theft of these documents remains unresolved. And in other words, Mr. McConnell and his law firm's participation in this ongoing dispute remains unresolved. And I don't know why the majority leader would choose to bring up a nomination of somebody for a lifetime appointment to the federal bench when serious allegations about his law firm's participation and his personal participation in the theft of corporate documents in pursuit of litigation while that remains unresolved. I think it's a terrible mistake. I know the senator from New York suggests that we ought to just go ahead and vote on cloture because he knows then that because our Democratic friends control 53 votes in the Senate that that Mr. McConnell will be confirmed. But I'm concerned that the ethical allegations made against Mr. McConnell and his law firm remaining unresolved like this is a terrible time for us to be voting on a lifetime tenure. If he were to be confirmed and we find out later on that there were actually that the court actually finds that he did participate in this conspiracy to steal these corporate documents, what would that say about the U.S. Senate and about this process, our deliberative process? I think it would be a scandal, and it would be a scandal. Finally, let me just say that I've expressed my concerns previously about the scheme that a group of very smart trial lawyers have dreamed up to sue legal industries for huge amounts of money by making alliances with state attorneys general and then suing in the name of the state, but then in the end settling these cases for billions of dollars, in some cases hundreds of billions of dollars, and these lawyers reaping a windfall of billions of dollars in attorney's fees. And something that Stuart Taylor, one of the, I think, more level-headed commentators about legal matters, has said that this has indeed morphed the rule of law into the rule of lawyers. And ultimately, consumers have to pay more in terms of higher prices, and the lawyers reap a windfall. The very same lawyers who are hired through these no-bid, non-compete contracts are indeed the political supporters of these very same attorneys general, raising at least the appearance of impropriety in a pay-to-play system of providing litigation opportunities to these lawyers from which they reap billions of dollars and after which they funnel campaign contributions back to the very same state officials who've in fact authorized them to sue on behalf of the state. This is unseemly, to say to the very least, about it. Finally, I would say Mr. McConnell continues by his own admission to be eligible to receive up to $3.1 million a year in one of these shakedown industry lawsuits where these trial lawyers have worked with state attorney generals to sue on behalf of the state, not in cases that were actually tried, but were actually settled under threat of under an existential threat to these businesses and these industries. At a time when we're talking, as Senator Portman did, about job creation, the idea that we would be confirming a lawyer to a lifetime appointment at the federal bench, that he could then serve as a venue, given the venue shopping that frequently goes on in this type of litigation, we can expect that if Mr. McConnell finds himself confirmed as a federal judge, that he will, in the future, that litigants will find his court in a warm reception in his court to these ethically dubious schemes. I just think it's a extraordinary circumstance according to the standards set by the so-called Gang of 14. It's not something we're going to be doing often, but when a ethically flawed nominee like this nominee is proposed by the President of the United States on three different occasions, and Senator Reid, the Majority Leader, as is his right, tries to slip this stealth nominee through when people are paying attention to other things, and we haven't had adequate time to debate or expose the records so senators can make a good judgment about the facts and about doing their duty as an individual senator. I just think it's a terrible shame. So I intend to vote against cloture, and I hope my colleagues will, so we can have additional time to review this nominee's credentials and make a good faith assessment on behalf of all of our constituents.
Madam President.
Madam President, I yield the floor.
Senator from Rhode Island.
Madam President, I propose unanimous consent that would recognize myself for 5 minutes, Senator Grassley for 5 minutes, Senator Leahy for 5 minutes, and then Senator Snowe and Senator Landrieu for 10 minutes. Each.
Is there an objection? Without objection.
Thank you very much. Madam President, this is not a stealth nomination. Mr. McConnell has been approved and voted by the committee 3 separate times. This has lasted almost 3 years. There's nothing stealthy about it. That is an exaggeration and completely inaccurate. Let me suggest to all the ethical claims or allegations, Mr. McConnell has never been charged with an ethics complaint, never been found by a court to have done anything but honorable service as an attorney. All of these issues of the so-called stolen document were completely vetted and reviewed by the trial court in Rhode Island, Judge Silverstein. That is the first place that the defendants took their complaints about unethical behavior. Judge Silverstein found no merit and, in fact, commended Mr. McConnell for his involvement and the involvement of the counsels. Let me also try to respond to the issue of these so-called shakedown suits. Well, one of the participants in those shakedown suits is a current circuit judge, which I believe my colleague voted for. He's on the 3rd Circuit in Pennsylvania. He was the Republican Attorney General of Pennsylvania. He worked with Mr. McConnell in a path-breaking suit to bring tobacco companies to justice and to provide each state, including Texas and Iowa and Rhode Island, billions of dollars to relieve the dangers and the harm caused by tobacco. And these states gladly took the money and gladly participated. That and this judge, this Federal Circuit judge, testifies to the integrity and the character of Jack McConnell. And I am indeed appalled that his integrity would be questioned in such a way. With respect to his statements before the Senate Judiciary Committee, they have been consistent. They have said, in respect to these documents, these stolen trade secrets, I saw, in his words, I saw the documents prior to the suit being filed in Ohio. Again, this suit, this second suit, is really retaliation by the companies in order to express their great anger at being sued in Rhode Island. But I saw the documents prior to the suit being filed in Ohio. I briefly saw them when they were first faxed to our law firm, and then again a few years later. He makes no bones about the fact he received those documents. He was a managing partner or a leading partner, and he quickly passed them on to the lawyer who was doing the work. I saw them when we submitted 1 page of the documents to the court in Rhode Island. I would not say I was familiar with them in any fashion. And then the debate seems to be, the quibble seems to be not about a clear misstatement, but the fact that in any fashion. I think he was being very careful, because I think the lawyer says that I was familiar with the documents means you've read them thoroughly, you've studied them thoroughly. He couldn't say that. This came over his desk, was quickly out of his hands, and quickly in the hands of others. Again, all these allegations of
unscrupulous behavior, unethical behavior, have never been supported by any finding. There's a case in Ohio. It is not directed against Jack McConnell. He's not a named party. It is his law firm. He is one of many, many people. There are suits filed against the United States Senate, I would suspect, frequently. Are we all involved? I suspect not. And finally, let me just suggest this notion of, well, this is just this elaborate arrangement between attorney generals, between Jack McConnell. Jack McConnell was originally brought into this suit on lead by a Republican attorney general. The succeeding attorney general was indeed our colleague Sheldon Whitehouse. They scrupulously had a contract that was reviewed by the court. In fact, one provision of the contract said the court judge had to approve any payments to McConnell's firm. That's the judge's call, not the Attorney General's call. And interestingly enough, this whole suggestion that there's this cozy deal going on here, Jack McConnell is such a principled and active Democrat that when my colleague ran for governor of Rhode Island, Jack McConnell managed the successful campaign of his opponent, a woman who he felt more aligned with in terms of her philosophy, in terms of her commitment to issues he cared about. Senator Whitehouse lost that race. Unfortunate for the state of Rhode Island, fortunate, I think, for the United States Senate. So this suggestion and this notion that this is all a cozy deal that's been worked out is absolutely erroneous. The overwhelming consensus of lawyers, clergy, everyone in Rhode Island, business leaders, is this is one of the most honest and ethical persons you would ever want to know. And frankly, that was the ultimate issue that prompted me to recommend him to the President of the United States. He is a decent man of character, and the assault on his character is, I think, unprecedented, as well as this assault on the notion of allowing a district court judge to have an up or down vote.
Senator Myla.
I rise to oppose the cloture motion on Jack McConnell, who has been nominated District Judge, Rhode Island. In the first few months that I've been ranking member of the Judiciary Committee, I've worked in good faith to move forward with consensus nominees. We have taken positive action on 68% of the judicial nominees submitted in this Congress. Despite my efforts, friends on the other side of the aisle and the President's top lawyer continue to claim that we're not moving fast enough. There are additional consensus nominees that the Senate could turn to. We could confirm additional district judge vacancies, as we have been doing. But rather than continuing to move forward with consensus nominees, the majority leader chose to throw up a detour and proceed to one of the President's most controversial nominees, Mr. McConnell. It seems no good deed goes unpunished. Before turning to Mr. McConnell's record, I want to just say a few words about the use of extended debate in considering judicial nominations. My friends on the other side have made some comments on this issue that are pretty difficult to understand given the record there. First, with respect to district court nominees, and contrary to what my colleagues have suggested, there have been, in the past, filibusters of district court nominees. Most recently, the Democrats successfully filibustered a district court nominee in 1999, Mr. Brian Stewart, by a vote of 55 to 44. Judge Stewart was ultimately confirmed, but the fact of the matter is that district court nominees have been filibustered, and it was Democrats who first took the step. On circuit court nominees, the record is far worse. I would note that I do not necessarily like to vote against cloture on judicial nominees. I do not take these votes lightly, but these are the rules that the other side instituted. Under the precedent and threshold that the Democrats first established, members must decide whether they believe they should move forward to a vote on confirmation of this nominee. By any fair measure, Mr. McConnell qualifies as a very extraordinary circumstance. I have reached this conclusion based on a number of factors, and I want to discuss just a couple of these reasons now. I am particularly troubled by the way Mr. McConnell handled himself before the committee. I believe Mr. McConnell, at best, misled the committee when he testified about his familiarity with a set of stolen legal documents that his law firm obtained during the lead paint litigation. When asked about these documents during his committee hearing, he testified that he saw the documents, quote-unquote, briefly, but that he was not familiar with them, quote-unquote, in any fashion. But several months after his hearing, Mr. McConnell was deposed under oath about those same documents. In his sworn deposition, Mr. McConnell testified that he was the first lawyer to receive the documents. He drafted a newspaper editorial citing information that came directly from those documents. He testified that he reviewed and signed a legal brief that incorporated the stolen documents. And even though he told the committee that he was not familiar with the documents, quote-unquote, in any fashion, during his deposition, he testified that he did not see any indication on the documents that they were confidential or secret. How could he know the documents were not confidential or secret if, as he testified before the committee, he was not familiar with them in any fashion? Given these facts, it is hard to square Mr. McConnell's testimony before the committee with his sworn deposition testimony a couple months later. Now the litigation over these documents remain ongoing. We do not know how it will conclude. We do not know whether Mr. McConnell and his law firm will be held liable for the theft of these documents. But what is the Senate going to do if we confirm this individual, but at some later date he or his law firm is found liable for theft? At that point, it will be too late. Members will not be able to reconsider their votes. The Wall Street Journal recently opined that Mr. McConnell's changing story, quote, changing story about his lead paint advocacy is enough by itself to disqualify him from the bench. I could not agree more, and I would ask that a longer statement be put in the record, and I'll yield back the time that was allotted to me.
Without objection.
Madam President.
Senator from Vermont.
Madam President, I hope that all senators have a chance to consider the remarks of the two distinguished senators from Rhode Island on this nomination. I don't think anyone can listen to their remarks yesterday and today and come away doing anything other than voting for cloture. Likewise, Senator Whitehouse has spoke this morning and has shepherded this nomination through the Senate Judiciary Committee, has done an outstanding job. And I was moved by the comments in the speech of Senator Reid I heard as I came on the floor. They've set forth not only the merits of the nominee, but also what's at stake for the Senate and the country. If the Senate Republicans take the virtually unprecedented action of filibustering a federal district court nominee, Jack McConnell has bipartisan support from those in his home state. Leading Republican figures in Rhode Island have endorsed his nomination. You know, Madam President, a few years ago, Republican senators argued that filibusters of judicial nominees were unconstitutional. They said every nominee was entitled to an up or down vote. Well, of course, they said that with a Republican president. Now, suddenly, things have changed. At that time, a number of Republican senators joined in a bipartisan memorandum of understanding to head off the nuclear option and agreed that nominees should only be filibustered under extraordinary circumstances. Now, no one with a straight face could argue that this federal district court nomination presents anything approaching the extraordinary circumstances that might justify a filibuster to prevent a vote on the nomination. And it would be unfortunate if senators were to knuckle under to the demands for a filibuster by special interest business lobbies. Mr. McConnell should not be filibustered for being a good lawyer, although that's what's really at the heart of his opposition. The corporate lobby opposes him because he successfully represented plaintiffs, including the state of Rhode Island itself, in lawsuits against lead paint manufacturers. Now, some here may support the lead paint industry. That's their right. I support the right of this attorney to bring legal claims based on the poisoning of children by the lead in the paint to hold those responsible accountable. You can support the lead paint manufacturers, or you can support the children who are poisoned. I'll stand with the children. And that's what Mr. McConnell did. That's why these lobbies oppose him. No senator should oppose Mr. McConnell for doing what lawyers do and vigorously representing his clients in lawsuits. That's not a justification to filibuster this nomination. He has testified. He demonstrated he understands the differences between the role of the judge and the role of the advocate for one of the parties. Now, I've made it a practice as chairman of the Senate Judiciary Committee to respect the views of home state senators from both sides of the aisle. I've encouraged President Obama to work with home state senators from both sides of the aisle. I know Republican senators used to defer to home state senators on federal district court nominations. That was their justification for voting both for or against nomination during the last several years. But that rule is suddenly changing as Senate Republicans abandon that deference and engage in a filibuster of this federal district court nominee and ignore the strongly held views of home state senators, then they're going to be undercutting the understandings and past practices of chairman of the Senate Judiciary Committee. When home state senators is widely respected and serious about the rule of law as the senators from Rhode Island endorse a federal district court nominee, the nominee should not be filibustered. They never have. I've been here 37 years, Madam President, and we used to treat each other as well as such nominees willing to serve on the bench with respect. I hope that today the Senate will return to that tradition. I hope the Senate Republicans will not go down the dark path on which they are headed. Senator Reid spoke yesterday of the precipice on which the Senate is poised. Senator Whitehouse and Senator Feinstein have spoken eloquently on this issue as well. So I'd urge all senators, both sides of the aisle, to do the right thing to honor our constitutional role and traditions, to vote in favor of ending this filibuster, and then allow the nomination of Jack McConnell to be voted yes or no. Madam President, I serve the balance of my time. Yield the floor.
Senator from Maine.
Thank you, Madam President. I rise today, regrettably, as ranking member of the Small Business Committee to announce that I'll be opposing cloture on the pending legislation regarding small businesses. I've reached this decision after much deliberation because I support the underlying legislation. In fact, I championed the Small Business Innovation Research Program since its inception, 1982, when I was serving in the U.S. House of Representatives. But regrettably, there's been a disturbing trend in this body over the past several years of disregarding minority rights and flat-out disallowing votes on our amendments. We were informed earlier this year that we would have an open amendment process on legislation in this Congress. We were told, let's let the Senate be the Senate again, and I couldn't agree more. Let's allow senators to offer amendments and have votes on them. That's the Senate that I know, and the one that has served our country so well since it first convened in 1789. As we all well know, the Senate has traditionally been a place where the rights of the minority are protected and where constructive debate is the rule, not the exception. It is supposed to be the institutional check that ensures all voices are heard and considered. Because while our constitutional democracy is premised on majority rule, it is also grounded in a commitment to minority rights. The fact of the matter is we have been considering the Small Business Innovation Research legislation since March 14th, a month and a half ago. Over the course of that time, when excluding weekends and recesses, the Senate was in session 15 days. And in those 15 days, we had merely 3 days in which the Senate has held votes related to this legislation, just 3 days. Furthermore, we have voted on 11 amendments out of 137 amendments filed prior to the Easter recess, which hardly represents an open amendment process. So we have 137 amendments filed. What do? We don't hold votes or debate these issues, allowing these amendments to be offered. We go on a 2-week recess, a fact that was not lost on the American people. What they saw was business as usual in Washington, acting as if there's nothing wrong in America today. So it's disappointing to hear the statements that it's Republicans that aren't allowing this bill to move forward. We're more than ready to move forward, Madam President, with votes on amendments, then onward to final passage. That's how the process works in the United States Senate. We could have already been at that point if we had been given the time instead of having recess and days off and morning business. Indeed, during the majority of the squandered time of the past several months spent not on this legislation but in quorum calls and morning business, there was nothing else commanding our attention. There was several days devoted to the continuing resolution. I understand not having votes on those days, but just 3 days for votes out of 15 is unfortunate, not to mention underachieving. We could have held votes on any other days. Voting is our primary responsibilities, as are amendments to flesh out the legislative process. We should have had a vote on the legislation that I was offering an amendment in conjunction with Senator Coburn and 6 other co-sponsors on regulatory reform to reduce the burden on our nation's small businesses. This would have had a direct impact here and now on the ability of small businesses to create jobs. I'm mystified as to why I cannot have a vote on this regulatory reform amendment as a ranking member of the Small Business Committee. In November, the Senate Small Business Committee held a hearing on regulatory reform. It was noted in that hearing that a 30% reduction in regulatory costs, an average 10-person firm would save nearly $32,000, enough to hire 1 additional individual. After enduring 26 straight months with unemployment at or above 8%, it's more imperative than ever that we finally liberate American small businesses from the regulatory burden that diminishes our ability to compete globally and create jobs at home. The regulatory reform amendment that I'm proposing with Senator Coburn, strongly supported by a variety of small business community organizations, the NFIB, the Chamber, 30 other groups, and I ask unanimous consent, Madam President, to include those in the record.
Without objection.
We have taken great strides to address the concerns of those from across the aisle, but they keep moving the goalposts. For instance, some didn't like our definition of indirect effects and costs with respect to evaluating the impact of regulations on small businesses. So we agreed to take the language that was initially proposed by Dr. Sargent with the Office of Advocacy at the Small Business Administration. He's the President's top small business regulatory appointee. It was expressed that the Office of Advocacy would require more funding to carry out these additional responsibilities. I agreed, and we proposed increased authorization for funding for this office. There were concerns with our language that would require that the rules sunset if agencies fail to review the rule as required by law, by the way. So we developed a compromise that would instead have a stick of reducing an agency's operating budget by 1% if it failed to comply with its review requirements under law. Moreover, includes several safeguards to allow the agency to have multiple bites out of the apple to satisfy their legal requirements. And we heard that some Democrats might oppose adding regulatory review panels at every agency. So we proposed a modest phase-in approach of 3 additional agencies per year over 3 years. After all, what's wrong with having a review panel established for small businesses, for agencies, when they're proposing rules? Let's determine whether or not those rules are going to affect small businesses before they're implemented in the rulemaking process, not after. You know, I hear here in the United States Senate, well, we'll see. We'll let the rules take effect and then see what happens to small businesses afterwards. Does anybody understand what that means for a small business on Main Street in America? To have to implement a regulation that's handed down from the federal government, the cost of compliance, the added, number of employees it requires just to deal with the regulatory burden. They can't afford it. And after all, we're in an age of high unemployment. It is persistent. So we could deal with this issue here and now. We've had a number of hearings over time of regulatory reform. The Government Operations Homeland Security Committee has had hearings on regulatory reform. The time is now to address it. And furthermore, what is the problem with allowing a vote on this amendment? That's what I don't understand, Mr. President. Why can't I have a vote on the amendment on regulatory reform? If those on the other side do not want to support it, they can vote against it. But let's have a vote. Let's have a debate. What else are we doing, Mr. President? What else are we doing? He just came off a 2-week recess. We're limited in time to debate this issue. We're limited in time. I cannot imagine if anybody went home and talked to small businesses on Main Street or to the average person who's searching for a job desperately, that they wouldn't connect with the world here, that we got to do something about it. It's not about worrying about lunches. It's about doing our work here in the United States Senate and doing it however long and however hard it is, but to do it. That's what this issue is all about. It's about doing things that are going to matter on Main Street. And regulatory reform matters on Main Street. We can talk about it endlessly. The time is now to act, Mr. President. That's what this is all about. And let's the Senate work in the traditions of the United States Senate, an open, deliberative process. When we had the continuing resolution, we had 700 amendments in the U.S. House of Representatives. What amendments did we have here? And the same is true as now. They're shutting down the process. I'm told we get 137 amendments. And I say, yeah, what to do? Go on recess for 2 weeks. I mean, the point is here, we've got a serious problem in America. It's a persistently high unemployment. It's subpar growth. The economic conditions are deeply troubling. We have to get the show on the road, and that means regulatory reform. It is one of the chief, foremost concerns among small businesses. Among the plethora of concerns they have about what we're doing or not doing, one of the foremost issues is regulatory reform. And we're dithering. And I can't even get a vote on the amendment. Vote yes or vote no. Let's debate it. Is there anything else we're doing in the United States Senate? Can somebody tell me? Because we're not. We just came off a 2-week recess. And I'm mystified why we're just driving this to a cloture vote, and I'm denied a vote on an amendment that is so relevant to the well-being, to the survival of small businesses than regulations. $26 billion in increased costs and regulations last year, Mr. President. That's on new regulations. The total cost of $1.7 trillion overall. Some have debated that cost. They said, oh, that's not a true cost. They said, you know, no, it's this cost. It's a lesser cost. You know, some are saying, well, you know, it's less than $1 trillion. Why? Because they don't count the IRS. Well, you ask a small business if IRS regulations aren't hampering their well-being, it's not suffocating the entrepreneurial spirit in America? Well, I think so. You know, or the FCC, or all the myriad of other independent agencies that are not included. That's the OMB study. They're saying, well, we don't include those, because that doesn't really have an impact on small businesses. Oh, really? I suggest everybody take Main Street tours and see what's happening. If we're wondering why we can't create the jobs that's necessary for the well-being of America, then just look to right here. We're shutting down the process with cloture votes. For what? Because we can't have a debate. We can't have
The
votes.
senator's time has expired.